Hello, my name is Shannon Gunn Emery, and I'm one of the lawyers with Gunn Law Group in Edmonton, Alberta. Now, if you're like me, you really enjoy going to sleep with someone talking at you. You might not find that hard to believe, considering that I record podcasts, I do audiobooks, and I talk pretty much for a living. But, believe it or not, I also like to listen to other people talk. In fact, one of the things I like the most is to let go of the stresses of the day by snuggling down into my bed and listening very attentively as someone else speaks. Don't get me wrong, I know I'm blessed and I have a good life, but there are stresses, and I'm sure that is the same for you. Sometimes I go to audiobooks, sometimes podcasts, and sometimes I go for sleep stories. These are stories that are designed to help you fall asleep. With a voice of an almost hypnotic narrator, you can almost be asleep in no time. It occurred to me, as I was looking for a sleep story with a criminal slant, that there aren't many of them out there. I'm not sure why that is, but I thought I would fill in the void. So take a nice deep inhale and exhale out, and get ready for Gunn Law Group's sweet, stabby sleep story. Tonight's story, dear listener, is based on true events, all related in a case called Regina. Regina because, unlike some of the people we are going to hear about, the Queen at that point was still very much alive. Getting back to the name of our story, it was Regina and Sullivan. It came out from the Supreme Court of Canada last year in 2022. I felt this would be the perfect case for a sleep story because, as you will hear, it involves two sleepy sons who end up doing stabby things to their parents. This is not supposed to give you nightmares. Just focus on your breathing. Think about how the breath feels as it enters your body, and then as it leaves your body, and you're letting everything out. You're relaxing. You're letting go of all those stresses. There is nowhere you have to be, nothing you have to be doing other than concentrating on my voice and listening to this story. Let's get started. As I said, the Sullivan case involves two men, David Sullivan and Thomas Chan. Now, these two men did not know each other. In fact, I'm guessing they lived very far apart from each other, but at some point, their lives were meant to intersect with each other. Now, snuggle down in your blanket, get as comfortable as you can, because we are about to start our story. Once upon a time, in a very strange land far, far away, Ontario, Canada to be exact, lived the two men at the heart of tonight's story. Let's start with David Sullivan. After all, the case is named after him. David Sullivan was 43 years old and living with his mother when the action in this story took place. I wonder if Mrs. Sullivan enjoyed having her 43-year-old son still living at home with her. I would bet that if she were to do it all over again, she would have kicked him out at 18. Whether it was because she was cooking with cheese or some other reason, there he was, still living in her house, nearly half a century after being born. I agree with you, dear listener. That is already a bit of a sad start, but I am bound to tell you the real facts of this case. So there he was, living with his mother, not perhaps in her basement, but somewhere in her house, when the Stabby incident happened. Before the unfortunate events which I am about to relate had occurred, there were some concerns about David's well-being. He had apparently indicated 3 months before the Stabby that he was convinced that the planet would be invaded by aliens that were already present in his mother's condominium. Don't forget, these are true facts. You can look them up on Canly. Don't believe me? Well, check out paragraph 9. Anyway, continuing on with our sweet Stabby story. It wasn't necessarily his mental illnesses that caused the Stabby. Mr. Sullivan had been prescribed Wellbutrin. You've probably heard of it before. He was taking it to help him quit smoking. Everyone in this story likely would have been much better off if he had just continued taking a puff every now and then. But no, he was determined to quit, and his doctor prescribed him this medication. Unfortunately, David didn't read or follow his doctor's directions about how much of Wellbutrin he should be taking. You know where this is going, don't you, dear listener? Psychosis is apparently a side effect of the drug. It probably wouldn't have been as big a side effect if he had not taken 30 to 80 Wellbutrin tablets in a suicide attempt. I'm guessing we are having the same thought. Why didn't the doctor prescribe a nicotine patch? That would have been so much better. But I suppose that if he had plastered his body with 30 to 80 patches, we might have been in a similar situation. Another mystery that will remain unsolved. Not surprisingly, the drugs prompted a psychotic episode, during which time David woke his mother in the middle of the night to tell her that an alien was in their living room. Why did his mother not just run away when she heard this craziness from her son? At some point, while he was still raving about aliens, David had picked up a knife. Now, you would have thought that also would have given his mother some reason to be concerned. Nevertheless, she and her armed son went to the living room, which was apparently occupied by the said alien. Maybe David's mother wanted to reassure her 43-year-old son that there were no aliens by checking under the couch or opening the closet doors and showing him that there really wasn't any monster there. Apparently, she did not convince David, as he seemed to feel that she was the alien, and he stabbed her over and over again. She died before trial of unrelated causes. I think, though, that it is fair to say the stabbings didn't help. Now I just know you are thinking to yourself, but what about Mr. Chan? Didn't you say something about a Mr. Chan? Yes, dear listener, I did. I got distracted by Mr. Sullivan, but as I said, Mr. Chan was destined to get to know the circumstances of Mr. Sullivan quite well. Mr. Chan had argued that his stabby was as the result of a brain injury. But, as you will hear, other forces were also at play. Our poor, brain-injured Thomas had been with friends when he decided on that fateful night to take psilocybin, also known as magic mushrooms. If there was magic in those mushrooms that night, I am sorry to say it was a dark magic. Thomas had tried magic mushrooms before and had really liked them. He had a little bit, and then it was a little like Goldilocks and the Three Bears. His first try was just not very satisfactory, so he took a second dose. Towards the end of the night, he began acting erratically. Frightened, he went upstairs where he woke up his mother, his mother's boyfriend, and his sister, and luckily he didn't stab any of them. Then Mr. Chan took off from the home wearing only a pair of pants. I guess most people should be happy that he at least had pants on. His family and friends pursued him as he ran towards his father's home a short distance away. Can't you just picture them? Mr. Chan running in his pair of pants, and the parade of friends and family following him as he ran down the streets. I don't know about you, but that kind of reminds me of Wee Willie Winkie running through town. Our Wee Willie Tommy broke into his father's house through a window, even though he normally gained entry through fingerprint recognition on a home security system. I do find it curious sometimes, the details of facts that the courts seem to feel are relevant and need to be included in a judgment. And these are all true facts, except, of course, when I tell you I'm using my imagination. Believe it or not, I'm actually reading right now from the case. Yes, once inside, he confronted his father in the kitchen and did not appear to recognize him. He shouted that he was God and his father was Satan. Now, dear listener, I have never read anywhere in the Bible that God stabs Satan. I believe God always wanted Satan to come back to the light, but either Thomas had forgotten this part of the Bible or he was working off of a different version. There are so many versions out there, the Gideon's Bible, the St. James Bible. Really, if he had used the St. James version, the stabby might not have happened at all. But we cannot go back in time and change the facts. Mr. Chan, after shouting that he was God and his father was Satan, proceeded to stab his father repeatedly. Stabby, then stabbed his father's partner. More stabby. When police arrived, he complied with their demands, although at one point he struggled with what a police officer described as super strength. That is again a quote. And you thought that reading case law was boring. No, my friends. I just know you're going to want to snuggle down into your beds from now on with a good Canley case. Or maybe you just prefer to listen to Gunn Law Group's sweet Stabby sleep stories. The parties in the case of Mr. Chan never could really agree whether he was suffering from a brain injury, and if so, whether it played any part in his violent conduct. Mr. Chan argued that but for the brain injury, he would not have been psychotic, even though he had been consuming psilocybin. No, those magic mushrooms had nothing to do, according to Mr. Chan, with his stabby. The Crown was concerned that Mr. Chan's psychosis was as a result of voluntary consumption of mushrooms, whereas, of course, the brain injury hadn't been voluntary. The court did not describe exactly what had happened, but said the brain injury was mild. Maybe little Tommy got hit in the head with a tennis ball, or maybe he fell down some stairs and hit his head after he failed to do up his shoelaces. I guess we'll never know. In any event, the court held that the mild brain injury was not the root cause of the stabby. The judge at trial wasn't sure that the brain injury really rendered Mr. Chan incapable of appreciating the nature and quality of his actions or knowing they were wrong. Instead, the judge found, what a shocker, Mr. Chan experienced a sudden onset of psychosis that coincided directly with the ingestion and absorption of magic mushrooms. That is a quote. Now you may be thinking, well, there you are. What a coincidence that two men who were in a sleep-like state ended up stabbing their parents. That is very unusual, and it is unusual that it would be in the same province. It is funny to think how Ontario really is a strange, far-off place for Albertans. Very odd things happen, not just politically, but legally too. But, my dear listener, get ready, because the story takes on more twists and turns. Legal twists and turns that are very interesting indeed. We return now to Mr. Sullivan's case. Remember how he had taken just a wee bit too much Wellbutrin and ended up not being nice to his mother? Well, the Crown prosecutor argued that he was not allowed to raise the defense of automatism if his affliction was self-induced. The trial judge agreed with the Crown prosecutor, and Mr. Sullivan was convicted of aggravated assault, assault with a weapon, and 4 counts of breach of a non-communication order. The decision is silent at the Supreme Court level on those breaches, but I rather like to imagine David being seized with remorse for what he had done, and in flagrant defiance of the no-contact provision that a court had imposed for the protection of his mother, rushed to the hospital to tell his mommy he was sorry. He tried 4 times to say he was sorry. I also like to imagine Mrs. Sullivan calmly calling the police to get her son out of the hospital room. David received a global sentence of 5 years for his actions. Essential to the court's reasoning was Section 33.1 of the Criminal Code. That is the code section that the judge said applied to preclude the automatism defense if intoxication was self-induced. Now, Mr. Sullivan's case was heard before Mr. Chan's case, and that, my dear listener, becomes a very interesting fact that we will come back to many times after. Please note, Mr. Sullivan never argued the constitutionality of Section 33.1 at trial. But Mr. Chan took a somewhat different approach. Yes, the time is right to return now to the godly Mr. Chan, who had attacked his father and his father's partner with a knife. What did he do at trial? Well, you remember, he first argued that he had a brain injury, but the evidence disclosed only a mild traumatic brain injury, and the trial judge was not convinced that was the problem. It was the magic mushrooms that did it. Mr. Chan was convicted of manslaughter and aggravated assault. He was sentenced to a global sentence of 5 years, reduced to 3.5 years after credit reductions. It's kind of funny that Mr. Sullivan got 5 years too, and he actually didn't kill anyone. Isn't our justice system funny sometimes? I just laugh and laugh. Now, although that is an interesting twist, it's not the interesting legal twist that I'm going to tell you about. Mr. Chan, with super strength, did not end his criminal case there. He applied to reopen the case, to re-argue a constitutional issue. Thomas argued that a very wise old judge in another case, R. Macaw, the same as the name of the bird, had just the year before declared Section 33.1 unconstitutional and therefore presented a renewed opportunity to consider the question. Now, this is where the legal twists start coming in, and I'm going to give you a bit of a hint. This whole case is not so much about all the stabbies. No, it's more about, does one judge really have to follow the decision of another judge of the same court? So, for example, does a provincial court judge have to follow the decision of another provincial court judge on the same issue from the same province? Does a Court of King's Bench justice have to follow the same reasoning as one of their sister or brother judges? Mr. Chan argued that the judge in Macaw had declared Section 33.1 to be unconstitutional. Remember, that's the one that said you can't argue automatism if your state of automatism was self-induced. In Macaw, the justice there said she was bound by another case called Dunn, D-U-N-N. Yes, just like gun, but with a D. Justice Spies in Macaw held that once a provision is declared unconstitutional, it is invalid and off the books for all future cases. The judge in Mr. Chan's case was not impressed. He dismissed Mr. Chan's application to reopen the case. The justice said Macaw was not an accurate statement of the law, and he relied on Spruce Mills, a proper understanding of the rule of what we call horizontal stare decisis. Now, I am sorry, dear listener, but it really is going to be important to our story that we describe what is stare decisis what is horizontal stare decisis and what is vertical stare decisis. Stare decisis is Latin, and it means let the decision stand. Did that help you? No. The way we apply it in law is that it refers to cases where one decision binds the hands of another judge. When we talk about vertical stare decisis, we are meaning that a higher court's decision is always binding on a lower court. On the other hand, with horizontal stare decisis, we are asking how and to what extent one judge is bound by the decision of another judge of that same level of court and of the same jurisdiction. This case of Sullivan that I have been recounting to you tonight is all about horizontal stare decisis. Back to poor Mr. Chan's unsuccessful application to reopen the case. Noting that there were inconsistent rulings on the matter of the constitutionality of Section 33.1 across the country, Justice Boswell shut down Mr. Chan's arguments once and for all. Of course, he didn't do that, because that would end the story, and we know this sweet Stabby sleep story goes on. Both Mr. Sullivan and Mr. Chan decided to appeal their cases to the Ontario Court of Appeal. In fact, the Court of Appeal decided to hear the cases together. This is really when our two, we really can't call them protagonists, the two central figures in our story really come together. The Ontario Court of Appeal held that Section 33.1 was unconstitutional. Yes, dear listeners, another law struck down in its prime. The Court of Appeal held that Section 33.1 violated Sections 7 and 11D of the Canadian Charter of Rights and Freedoms. Oh, the Canadian Charter. A wonderful Canadian-made constitutional dream that other countries wish they had. Section 7 guarantees everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. Take a deep breath and drink that all in. Section 11D is the right to be presumed innocent. These are both lovely rights in the Canadian Charter, and the Court of Appeal found that Section 33.1 had violated them. How shocking! And those violations were not saved by Section 1. Section 1 allows for some flexibility in the Canadian Charter. It says that from time to time there may be reasonable limits prescribed by law on the rights protected by the Charter. But not in this case. Nope, the violations were not saved by Section 1. That meant that both Mr. Sullivan and Mr. Chan were entitled to raise the defense of automatism. Based on the findings of his trial, Mr. Sullivan's convictions were set aside and acquittals were entered. In the case of Mr. Chan, because no finding of fact had been made in respect of non-mental disorder automatism, they ordered a new trial. Then, of course, the powerful but unhappy Crown decided to appeal. And off the parties went to the Supreme Court of Canada. What, dear listeners, do you think the Supreme Court of Canada said about it? Do you think that they agreed with the Court of Appeal that Section 33.1 violated Section 7 and 11D? What do you think they said about Section 1 coming in to save the day? Well, of course, I'm not going to leave you hanging. I'll tell you the ending so that hopefully you can get a good night's sleep. The Supreme Court of Canada agreed with the Ontario Court of Appeal that Section 33.1 did indeed violate Sections 7 and 11D of the Canadian Charter of Rights and Freedoms, and those violations were not saved by Section 1. But that was really just a one-liner in the decision. The two remaining issues in the appeals were what really got the legal community humming. On what basis can a declaration issued by a superior court pursuant to Section 52 of the Constitution Act 1982, that's the section that allows judges to strike down legislation, or at least declare them to be invalid, on what basis can a declaration like that be considered binding on courts of coordinate jurisdiction, or the same jurisdiction? Now, only because I don't want you to be sitting there racking your brain wanting to know what was the second issue. What was the second issue? It's not a very interesting issue. You see, Mr. Chan, again with that super strength, decided to cross-appeal. Yes, from the Court of Appeal's decision where they ordered a new trial. He had won his appeal, but that wasn't good enough for Mr. Chan. He wanted an acquittal, or, if not an acquittal, a stay of proceedings, which has been called the judicial time bomb of all remedies. The Supreme Court of Canada said no. No, Mr. Chan, you are going back for a retrial. I am sorry, dear listeners, but I couldn't find out what happened to Mr. Chan at his retrial. I knew you would want to know, and I do too. And then I realized that this decision only came out last year, and it is very possible that the retrial either hasn't concluded yet or a decision hasn't been rendered yet. Now, back to the one issue that really rocked the legal community. It's horizontal stare decisis all over again. Mr. Sullivan, or at least his lawyer, was very much awake when he argued that, starting with the Dunn case, noted 4 separate Superior Court judgments that struck down Section 33.1. Are you wondering, like I, why he never argued the constitutionality of Section 33.1 at his trial? So curious. As the judge in the case of Dunn had found the law unconstitutional, Mr. Sullivan's lawyer argued that this should have invalidated the law for all future cases. The Supreme Court did not go that far. The court decided, however, to clarify the situations when a superior court may depart from a prior judgment of a court of coordinate jurisdiction. The standard is not that the prior decision was plainly wrong. I was glad to hear that, because what bothered me about that standard, personally, was that it meant that in some ways the second judge was sitting in appeal of the first judge's decision. And they can't do that. The Supreme Court went on to say a superior court judge in first instance should follow prior decisions made by their own court on all questions of law unless one or more of the exceptions in Spruce Mills, another case you could look up on another day, are met. Trial courts, they say at paragraph 75, should only depart from binding decisions issued by a court of coordinate jurisdiction in 3 narrow circumstances. 1. The rationale of an earlier decision has been undermined by subsequent appellate decisions. Remember how we talked about vertical stare decisis? Remember how the higher court's decisions bind the lower ones? If the trial judge didn't realize that one of those higher and mightier courts had already decided something completely the opposite way that the trial judge was thinking, that would allow another judge of the same court to go a different way and ignore the first judge's decision. Number 2. The earlier decision was reached per incurium. That means, again, a little bit of Latin to make you fall asleep faster through carelessness or by inadvertence. I know you're going to go around using the words per incurium all the time. Oops, sorry, I must have been acting per incurium when I dropped that glass on your foot. Oops, sorry, I was driving per incurium when I smashed into your house. Per incurium usually means, in the legal context, dear listener, that the judge made a mistake. But it's not just any mistake. The test is, did the court fail to consider some authority such that, had it done so, it would have come to a different decision, because the inadvertence is shown to have struck at the essence of the decision. It cannot merely be an instance in which an authority was not mentioned in the reasons. It must be shown that the missing authority affected the judgment. And finally, number 3. The earlier decision was not fully considered. In other words, it was taken in exigent circumstances. Those are the words of the Supreme Court of Canada. But what are exigent circumstances? Does this mean that the judge's robes were on fire and they had to yell out a decision quickly before they burned up or went poof? Well, not really. What the court said is, a judge may depart where the exigencies of the trial required an immediate decision without the opportunity to consult authority fully. In other words, the judge shot from the hip because they had to wrap things up quickly. It was a rushed decision, and therefore other judges don't have to follow it. And that, dear listeners, brings us close to the end of our story. Sullivan really is interpreted by the legal community as it's a race to the case. Whatever judge arrives at the issue first and decides it, well, that pretty much settles it for every other judge who comes along. In fact, one justice recently said it really took a lot of the fun out of being a Superior Court justice. I totally understand that. But when the Supreme Court says something, vertical stare decisis applies, and everyone does as they're told and live happily ever after. Or not. Thank you for joining me tonight. I'm Shannon Gunn Emery. Sweet dreams.